Please. Go ahead, Mr. Davies.
Thank you. So it seems circular, and I also think that we go down a dangerous, slippery slope when we start saying, well, in order to protect our way of life and our civil liberties, I may have to violate civil liberties of other people. The second concept that comes to my mind is the question of the onus. It seems to me that a fundamental feature of the fabric of Canadian society and Western democracies is that we as individuals have certain fundamental rights, and those rights are primary, and the onus is on the state to make a case as to when those rights are properly abrogated. So we even heard mention of the Charter of Rights and Freedoms. Yes, we are given fundamental rights as individuals, and those rights may be abrogated if the state can justify an abrogation of those rights as may be justified in a free and democratic society. So it's not for an individual to justify why they're entitled to their rights. As a matter of being a Canadian citizen, as a matter of fundamental liberty in our concept of democracy, we have those rights until the state justifies otherwise. I want to just talk a little bit about what we're dealing with here. We're dealing with the concept of giving police officers the right to preventatively arrest based on suspicion, and we're talking about compelling testimony from people, forcing people to testify, both of which I think are significant departures from our current legal system. In fact, I'm going to quote the CBA, which says, "These powers, especially the power to conduct an investigative hearing, represent a significant departure from powers traditionally available to investigate criminal offences." So where I'm going to try to go to is some fact. Because if we're talking about a justification for these powers, I think where we must all start from is the objective evidence. Now, we all know some basic facts, but I think they bear repeating. This is what we know so far, that these powers were introduced in 2001, and in 10 years, they have been used precisely once. Once in a decade. We know that after the original bill sunsetted since 2007, when these powers have not been in power at all, that we have not had any occasion to utilize these powers. We also know that since those provisions were allowed to sunset, that Canadian criminal law has continued to operate effectively. I want to also quote from the Canadian Bar Association submission that we received, and then I'll ask for some comment on this if I can, who said that they said that we must recognize that rules and procedures in Canadian criminal law, as they existed prior to the addition of sections 83.28 and 83.3, were effective for investigating criminal offences, including those associated with terrorism. We must recognize that the rules and procedures in Canadian criminal law, as they existed prior to the inclusion of sections 83.28 and 83.3, were effective in protecting people within Canada from the harm caused by criminal offences, including those associated with terrorism, and CBA has identified themselves as the national voice of the legal profession. So, here's my question. If we put these laws into place, they were used once. We have the Canadian Bar Association, the national voice of the legal profession, telling us that the criminal laws as we had at that time and since are totally effective in preventing us from terrorism. And we also know that standing in distinction to the fact that they were used only once, I can name you 5 cases of serious violations of Canadians' human rights. Mr. Arar, El Mahdi, El Malki, Nureddin, Chikawi. Can any of you comment on the evidentiary basis, the objective basis that we would, as parliamentarians, possibly have to proceed with a law that so fundamentally alters our Canadian legal system?
Well, I think, and that's the reason for sunset clause, is to, when they expire, to evaluate what is the evidence that you have in terms of what are the dangers that you are trained to seek. And I think it's no coincidence that at the same time as we're doing this exercise, and we should do it thoroughly, looking at the evidence that we have of abuses on one side and the lack of the need, particularly since 2007 that there hasn't been these provisions enforced when they were sunsetted, there have been prosecution for terrorism act that have occurred. So it's not as though the police is unable to act. On the contrary, I think they have been able to act. It's no surprise that now in the UK, the same process of reevaluating whether the strong and the difficult and dangerous tools like control orders ought not to be reevaluated. So the idea of stepping back and saying, you know, this was not necessary, it's no longer necessary, it's not the best way to go, it's better to invest in better intelligence than simply giving more powers, I think maybe a better assessment at this stage.
Thank you for your question. I agree with Ms. DesRosier, and you know, I don't like prognosticating forward or backward, but if I can use one example, it's, you know, you've been told by the minister and security agencies, RCMP, that they need these new powers. They have a lot of powers, not using those very well. But let's look back 25 years, the real significant terrorist attack that Canadians suffered, but as an Indo-Canadian, I can tell you was not acknowledged for 10 years as a Canadian tragedy, which I find a bit insulting as an Indo-Canadian, is the Air India terrorist attack. And would CSIS and the RCMP, let's pretend we can go back in time and give them these powers. Would that have saved those Canadians and others? I don't think so, because let's look at what Justice Major in his findings says. And I'll just give you a couple little snippets that caught my eye. CSIS surveillance was ineffective. Surveillance were unable to distinguish one traditionally attired Sikh from another.
Quickly, Mr.
CSIS
Mia.
failed to provide important information. RCMP wasted resources. Specific threat was not understood. Lack of cooperation between RCMP, CSIS. RCMP failed, and failed.
Thank you.
So at the end of the day,
thank you, Mr.
that's
Mia.
the problem,
Thank
not
you.
new powers.
I'm sorry.